Welcome. I'm Eileen Fleischman, Vice Dean for Alumni at the University at Buffalo School of Law. I am delighted to introduce Robert P. Fine as the Master of Ceremonies for today's program. Bob is a Buffalo native and a 1968 graduate of our law school. He is a founding partner of the Buffalo law firm Hurwitz Fine PC. In addition to a distinguished career in private practice, Bob has made extraordinary contributions to the bench and bar. He has served as the chair of the Merit Selection Panel for the selection of federal magistrate judges in the Western District of New York. He was vice chair of the New York Screening Panel for judges in the 4th Judicial Department of the state of New York. And he was vice chair and finance chair for the Roswell Park Comprehensive Cancer Center. In the law school, he served as president of the UB Law Alumni Association, as a member of the Dean's Advisory Council, and as an adjunct professor, teaching a course in buying and selling businesses. For the past 4 decades, Bob has been a great leader and a great friend of the law school. So it is with both professional and personal pleasure that I introduce our Master of Ceremonies, Robert P. Fine.
Thank you very much, Eileen. It's a pleasure to be here to welcome you to the presentation of the Edwin F. Jekyll Award to the Honorable Paul Laurence Friedman. I'm pleased to be here, not just because Paul's my cousin, or because we were each other's best men, but I'm here also because Judge Paul Friedman is truly deserving of being honored. And this occasion presents a combination of many factors. This award is presented by the law school at Buffalo, by the Law Alumni Association of Buffalo. Judge Paul Friedman is a native of Buffalo. And Buffalo, as you all know, recently suffered a tragedy. And you will hear much about the administration of justice and the rule of law today. I can assure you, the rule of law is being followed and justice will be done in Buffalo. Buffalo is known as the city of good neighbors, and so it has proved itself once again. Buffalonians have contributed literally millions of dollars to the families of the victims. I ask that we observe a moment of silence for the victims and their families. Thank you. It's a pleasure to present the distinguished people at the head table. From left to right, the Honorable Beryl A. Howell, Chief Judge of the United States District Court for the District of Columbia. The Honorable Jamie S. Gorelick, a partner in Wilmer Hale in Washington and a former Deputy Attorney General of the United States. Our honoree, the Honorable Paul Friedman. To my right, Dr. Satish Tripathi, President at the University at Buffalo. Aviva Abramovsky, Dean of the University at Buffalo School of Law. Jeffrey C. Stravino, a partner in the Buffalo-based law firm of Hodson Russ and the President of the Law Alumni Association. And Eileen Fleischman, the Vice Dean of the University at Buffalo School of Law and the person who deserves the credit for organizing this entire event. We have some special guests I'd like to mention. First, Liz Friedman, the wife of Judge Friedman, our honoree. we have in traffic and on his way a formal Jekyll Award recipient, Michael Battle. The incoming president of the Law Alumni Association, Elizabeth Krangle. Members of the Dean's Advisory Committee, Mason Ash, Douglas Dimitrov, Mary Joanne Dowd, and Christine Kohler, apologize. And, significantly, 12 of Judge Friedman's past and present law clerks. To begin our remarks today, I present Dr. Satish Tripathi. He is president of the University at Buffalo. He's a computer scientist and an academic administrator. Before coming to the University at Buffalo, he was the Dean of Engineering at the University of California in Riverside. He came to UB in 2004 as the provost. When John Simpson retired as president of the university in 2011, the Board of Trustees of the State University of New York had to look no further than the provost's office to find its new president. Widely respected, not only in the field of university administration, but throughout the Western New York community and beyond. President Tripathi.
Thank you very much, and good afternoon, everyone. On behalf of the entire UB community, I want to thank you for joining us as we celebrate this great law school tradition and this year's honoree. As we begin today's ceremony, I would also like to remember the 10 Buffalonians killed and the 3 wounded in the recent racist massacre that took place in our city a month ago. And they include alumna Pearl Young, who attended UB in her mid-30s while raising 3 children. With her bachelor's degree in social sciences, she worked with the elderly and at the time of her death at age 77, was substitute teaching in Buffalo Public Schools. Pearl Young used her UB degree for its highest purpose, to serve others. I find it very fitting that tonight we honor a UB alumnus who has used his law degree for the very same purpose. For more than 50 years, the Honorable Paul L. Friedman has championed the cause of social justice. Over the course of his illustrious career, he has worked to achieve ideals that our university community cherishes. Through his dedication to equity and justice for those who are marginalized and disenfranchised, he truly embodies UB's mission of excellence. And we are so proud of the inspiring example he has set for our UB Law graduates and our entire university community. In the aftermath of the racially motivated killing that took place in our city on May 14th, I reiterated those same values to our university community. As a scholarly community, we have both the power and the responsibility to combat hate. And to that, we are deeply committed. And that is why, more than 2 years ago, I formed the President's Advisory Council on Race. Since that time, the council members have worked diligently to identify ways that our university can dismantle structural barriers to equity and achieve social justice for our scholarly community. In these endeavors, we are so fortunate to have as our partner a school of law that has prioritized these values since its founding. I'm grateful to Dean Abramowski for embracing our cherished principles of social justice across all aspects of our students' legal education. She has enhanced the School of Law as a model of university engagement through its law clinics, a pro bono work of students and faculty, and its leadership and expertise in civic engagement and public policy. As we at UB translate our values into action, it is so inspiring to know that we are graduating law students who are dedicating their careers to the greater good, just as the Honorable Paul L. Friedman has done throughout his career. Before concluding, I would like to acknowledge the many luminaries in the law who are with us in person and virtually to pay tribute to the most deserving recipient of UB's Edwin A. Jekyll Award. And thank you all, and heartfelt congratulations to Honorable Paul Friedman. Thank you.
We will be eating throughout the program, so don't hold back, okay? We've got a group of distinguished speakers, and so please begin. Our next distinguished speaker is Aviva Abramovsky. She's Dean of the Law School at Buffalo. The Dean is an expert in many areas of law: insurance law, commercial law, regulation of financial entities, and legal ethics. She was appointed the Dean in June of 2017, and she was the first woman ever to be appointed Dean of the school. Before she came to Buffalo, she was a professor and associate dean at the at Syracuse University School of Law. The dean is widely respected by students, faculty, administration, and alumni. And I can tell you that I have known many deans from the time that I was a student, an adjunct faculty member, president of the Law Alumni, and a member of the Dean's Advisory Council. Aviva Abramovsky rates as one of the outstanding deans this school has ever had. It's my pleasure to present to you the Dean of the Law School.
Thank you for those incredibly fine words. You know, everyone always asks me what it's like to be the first woman dean, and I say I want to do a good job, so make sure that there's a second, and that I'm not the last. So I appreciate that. Welcome, and thank all of you for being here with us today. This is the first time that the Jekyll Award at the Law School and the Law Alumni Association's highest award has been presented here in DC. I am thrilled that we're able to present it here in our nation's capital at these times. Thank you to our university president, Satish Tripathi, for celebrating with us today and his steady support and strong leadership. It has been an ideal place to work through these past year's troubles. And thank you to our esteemed guests, Judge Beryl Howell, Jamie Gorlick, and Judge Friedman's friends and family members, as well as the distinguished jurists and leaders who have provided video remarks for today's events. We are honored to have each of you participate and join us. I'd also like to express my gratitude to the many others who have traveled to DC to be part of this event, our Master of Ceremonies, Bob Fine, and our outgoing and incoming Law Alumni Association presidents, Jeff Stravino and Liz Krengle, who are here from Buffalo representing the Law Alumni Association. And given the recent horrific events that occurred in our city, it is more important and more meaningful than ever to come together as a community and celebrate our triumphs. It brings us light, it gives us hope, and it reminds us that we are always stronger together. Together, we will continue to fight to eliminate hate and combat inequity. And as the state of New York's law school, together, we remain more committed than ever to our mission of promoting justice, just as our honoree has done throughout his career. I am very proud of the law school's Access to Justice initiatives and would like to take just a minute to give you a few examples. Our pro bono program and our amazing clinics are doing great work in the community, important work, needed work. advocating for victims of domestic violence, taking on gender equity and discrimination issues, addressing fair housing in Buffalo, and fighting for transparency in government. We remain focused on expanding access to education with programs like Discover Law, our summer program for promising undergraduate students from communities that have been historically underrepresented in the field of law. We welcomed 19 of them to O'Brien Hall earlier this month for an immersive 4-week live program exposing them to the law school experience. We are very glad to have them here with us. And we continue to work towards creating a more inclusive environment in O'Brien Hall by increasing diversity among our faculty, which includes the hiring of 3 new faculty members who will teach in our JD program beginning this fall, and the 4th for our growing undergraduate BA in Law program. These efforts are just a few examples of the critical work we are doing to cultivate lawyers and leaders who will ultimately excel in the profession and make their mark on our community and our world by serving justice and reflecting our values. Graduates like Judge Paul Friedman. When we think about what it means to serve justice, we think of fairness and integrity and ensuring equal protection under the law. Judge Friedman has devoted his career to those ideals. The presence of today's honored guests and video submissions we will see from leaders at the highest levels of the bar and bench are testimony to the exceptional regard we share for Judge Friedman and for all that he has stood for and achieved throughout his career. If it is unclear, we are very, very proud of him. In addition to his professional achievements, I'm sure we'll hear about many of them today. Judge Friedman also serves justice by ensuring that generations that follow him share his passion for the integrity of our judicial system and are given an opportunity to pass that passion into practice. He is well known for his mentorship. He's well known for his care. He's well known for opening the door, right? He does not lift the ladder up behind him, and to that we are incredibly grateful. He has done so by providing UB Law students with the highly coveted opportunity to intern for him at the U.S. District Court in the summers. He hosts an annual summer event at the federal courthouse, bringing together UB Law students with our extensive network of DC alumni. He's even offered tours to provide an inside view of the grandeur of the courthouse, one I took, and it is very impressive. And at every summer gathering, he shares an overview of some of the most impactful cases decided in his courtroom. Every law student in attendance gains a deeper understanding of how the court works and how justice is served and who the people are, and that they are welcome, and that they too can join the ranks of these people, just like Judge Friedman. He makes it real for them and for us. His impact on our law school and our profession as a mentor, a role model, and a distinguished jurist will be carried forward by the many UB Law attorneys he has inspired. We are privileged to honor him today with the Jekyll Award, our highest honor. Thank you, and congratulations, Judge Friedman. Thank you for all you've done. Thank you all for being a part of this special day. Please enjoy yourself. And thank you on behalf of the University of Buffalo, the State University of New York.
What a career Paul Friedman has had. It began in the very court where he now sits, as a law clerk to Judge Aubrey Robinson, and then on as a law clerk to Court of Appeals Judge Roger Robb, Assistant U.S. Attorney, Assistant to the Solicitor General, Managing Partner of the Washington Office of White and Case, President of the D.C. Bar, Secretary of the American Law Institute, a member of Judge Walsh's Iran investigation team. Knowing Paul Friedman for many years, his rise to success and his contributions to the law and the judiciary are no surprise. In undergraduate school, Paul was elected president of the Cornell University student government as a sophomore. In law school, some classmates were unsure where they wished their legal careers to take them. Not Paul Friedman. He knew he wanted to excel as a lawyer. He knew he wanted to be a trial lawyer. And yes, he knew at some point in time he wanted to be a judge. His qualities were evident even in those early years. He is smart, thoughtful, even-tempered, patient, a good listener. He has the ability to balance various interests. And Paul Friedman has always been committed to doing what is right and respecting the rule of law and the Constitution of the country. As I think of Judge Friedman's service as a judge, two examples come to mind, and you'll hear many more from the other speakers. John Hinckley attempted to commit murder of the President of the United States in 1981. In 1982, Hinckley was tried and found not guilty by reason of insanity. Starting in 2002, 20 years ago, Judge Friedman began hearings as to what was appropriate supervision and what would be appropriate freedom. Through 19 years of decision-making, Judge Friedman carefully balanced those interests until 2021, when he determined that there had been no indication of any new problems, and if there were none, John Hinckley would be granted an unconditional release in 1 year. 2 weeks ago today, Judge Friedman noted no new problems and granted Hinckley an unconditional release. Judge Friedman said that if the intended victim had not been president, Hinckley may have been released earlier. It takes a very thoughtful judge to balance the interests involved in that case before arriving at the many conclusions over the years. On November 6, 2019, Judge Friedman was invited to address the 11th annual Judge Thomas A. Flannery Lecture. Judge Friedman was concerned at that time, as were so many lawyers, judges, and citizens of our country, about the challenges to the rule of law, the independence of the judiciary, and the Constitution by the 45th President of the United States. He chose as his topic, threats to judicial independence and the rule of law. Again, he had to balance interests, judicial ethics and judicial propriety, with the need to defend democracy. He stated, "We are witnessing a chief executive who criticizes virtually every judicial decision that doesn't go his way and denigrates judges who rule against him, sometimes in very personal terms. He seems to view the courts and the justice system as obstacles to be attacked and undermined, not as a co-equal branch to be respected, even when he disagrees with the decisions." So compelling were Judge Friedman's words that the Washington Post took to its editorial page to laud his speech and noted what I have known for such a long time. Friedman was judicious long before he was a judge. As I think of Paul Friedman over the years, I'm reminded of the words of Katharine Graham, the longtime publisher of the Washington Post, as she spoke of her attorney, the legendary Edward Bennett Williams. She said, "The thing I like about Ed is he takes his job seriously, but he doesn't take himself seriously." The same can be said of Paul Friedman. He certainly takes his job seriously, but he enjoys conversing with friends. He enjoys discussing various subjects, and he loves hearing a good joke, which is very fortunate because he's incapable of telling one. Judge Paul Friedman, congratulations on this well-deserved honor, my friend.
Thank you, Bobby.
It's my pleasure now to present to you the Chief Judge of the District Court of the District of Columbia, Beryl Howell. Judge Howell was appointed to the District Court of the D.C. Circuit in December 2010 by President Obama. Prior to serving as a judge, Chief Judge Howell was an assistant U.S. attorney in the Eastern District of New York. She was a senior advisor to Senator Leahy when he was chair of the Senate Judiciary Committee and was a member of the 7-member U.S. Sentencing Commission. Ironically, Judge Howell assumed the seat in the court, which became open when Judge Paul Friedman took senior status. She began a 7-year term as chief judge in March of 2016. Her management skills, decisiveness, judgment have come together to make her a truly outstanding chief judge during the pandemic and the events of January 6th. She's made the system work well in spite of obstacles. Chief Judge Beryl Howell.
I'm not going to roast you, so you can relax. So good afternoon, everyone. It's really a pleasure to be here to meet so many people from the UB community. I hadn't known it was called that, but I learned something today. It's really my distinct pleasure to talk about Paul Friedman. He is a dear friend. He's a very respected colleague. As colleagues on the bench, judges are highly respectful of the difficult decisions that each of us must make, and we generally lend support, not critiques, of each other's work. So it's therefore one of the very rare opportunities I get here today to share with Paul and his very important University of Buffalo Law School community how I feel about how much he's accomplished as a judge. Paul's life, professional life, as you've already heard, has been truly bookended on the U.S. District Court for the District of Columbia, where he began a few months after law school clerking for Judge Aubrey Robinson. And then he went on to serve for 28 years as a district court judge. And as you've already heard, by taking senior status in 2009, he opened up a spot for his successor on his seat. And luckily, that happened to be me. And so my focus today is really on Paul's judicial career. You've heard some significant parts of it, but I'm going to go into a little bit more detail. But before I go into what he's done as a judge, I want to mention two aspects of his pre-judge days that made him both well-known to and prepared for our court. First, long before Judge Friedman was unanimously confirmed by the Senate, which is significant today, and appointed by President Clinton to the court in 1994, he was a fairly frequent contributor. One could go so far as to call him as a gadfly to the Senate Judiciary Committee's consideration of nominees to the DC federal courts. As president of the DC Bar in 1986 and 1987, he expressed his views about the need for diversity on the federal courts in DC, and was particularly critical of the Reagan administration's nominations to the DC District Court and the circuit, because all those nominations were only white men. He was also critical of what he called, in what I would say fairly strong language, the irrational, and that's quoting him, and unsupportable tradition of the past of choosing nominees who had little to no ties to DC, the DC Bar, or the DC federal or local courts. Paul's contributions in the late 1980s to the Senate judicial nominations process have not been forgotten and continue to this day to draw comments among his colleagues on both the district court and the DC circuit. Over time, the very important caveat that he put in all of his submissions to the Senate Judiciary Committee, that he was not expressing opposition per se to particular nominees, has been overlooked like so much fine print, leaving the overall impression that his pointed critique of the process spilled onto the nominee. I don't think that the DC Circuit judges at whose confirmation hearings he actually testified, expressing his concerns about the process, held it against him when reviewing appeals from his cases. But that is the thing about Paul. No such concern would have stopped him from expressing his principled position on both the appropriate qualifications and considerations for judges on the federal courts in DC. The second aspect of his pre-judge days meriting mention in informing his work as a judge is that he was appointed in 1990 by then Chief Judge Aubrey Robinson, for whom he'd clerked two decades earlier, as chairman of an advisory group to study the problem of civil justice delay. This group was set up to fulfill a statutory direction in the Civil Justice Reform Act of 1990 that all district courts had to comply with. I think some more seriously than others. But no surprise, Paul took his job as chair of the advisory group in DC very seriously. And he took a 3-year deep dive into how the judges on our court prioritized and resolved cases. And he issued a report in 1993 with almost 50 recommendations. And I hear sometimes today about some of those recommendations from colleagues who were on the court then. In a very funny twist of fate, I was a witness in 2011 to Paul's backpedaling on one of his aspirational recommendations, because among his 50 recommendations were some that were very commonsensical and I think are very common practice in our court today, but some were clearly aspirational. And one was that each judge establish a personal policy to decide dispositive motions within 60 days of the motions becoming ripe. That's the one I hear about from colleagues. All newly appointed district judges, you may or may not know this, attend a so-called baby judge school for boot camp on substantive and administrative topics. And Paul was one of the 2 mentor judges running my baby judge school. And I was, I have to say, the envy of all the other baby judges in this school, because I got to take my mentor home judge home with me to DC. So I was really one of the lucky ones. So many of the recommendations that Paul developed in his 1993 report before he became a judge were delivered at baby judge school in the form of refined advice that he gave to all of us about how to run chambers efficiently, how to manage our dockets efficiently. The other mentor judge pushed a 60-day to decision rule, saying that was the paradigm we should all strive for. And Paul helpfully provided a reality check that could just not be doable on our court, with so much of our docket taken up with challenges to federal agency actions based on huge administrative records and APA cases. So that was an aspirational recommendation that he gave in 1993. So one of his more prescient recommendations in 1993 was for the court to seek authority to appoint 2 additional magistrate judges to provide assistance, because our court had fewer magistrate judges per authorized judgeship than most other courts, certainly those in urban areas. And to this day, that remains the case. Our court had 3 magistrate judges back in the early 1990s when he made the recommendation, and we still have 3 magistrate judges. But the good news is 30 years after Paul made this recommendation for additional magistrate judge help, later this year in September, we're getting to appoint, we've been authorized to appoint a 4th magistrate judge. So his report from 1993, before he ever became a judge, has stood the test of time, even if implementation of some of the recommendations suffered a multi-decade delay. Through his DC bar activities and his detailed recommendations for the court and all the judges on the court, he was already very well known and highly respected before he became a judge as part of a large group of new judges affectionately called the Magnificent Seven, appointed by President Clinton at all around the same time. This was a group of big personalities to hit the court. And according to our court staff, and I quote, Judge Friedman always stood out as tough, thorough, and a demanding perfectionist, but at the same time always calm, polite, and courteous. Those are 2 different skill sets that are not always supplied at the same time, but he's able to do it. So what has he been doing during the past 28 years as a judge? He's been prolific. He's issued about 2,240 memorandum opinions. You may not even know that, Paul. That's an average of...
Working too hard.
Exactly. That's an average of about 80 opinions per year. And by way of comparison, that's an average that beats the Supreme Court's recent issuance of 66 decisions per year on average the last 3 terms. Notably, and this is the most important part of the 2,240 memorandum opinions, is over 1,100 of his opinions have been reported in the federal supplement. And for judges, that means something. It means that the publisher of the hard copy Federal Law Reporter volumes selected the opinion for publication because the opinion, and I'm quoting from the publisher, deals with an issue of first impression, provides a review of the law in particularly thorough fashion, involves newsworthy cases, or involves unique factual situations. So his body of written legal opinions fills many volumes of FSUP, FSUP second, and now on to FSUP third. That is a legacy contribution to the development of federal law from which all judges benefit. But his opinions appear not only in the FSUP reporters, but also in the federal law reporters for circuit courts of appeals. I continue to be impressed that Judge Friedman tests his persuasive skills on panels of judges by serving regularly by designation on circuit courts of appeals in other circuits, including the 2nd, the 9th, and the 11th circuits. Even after Judge Friedman authored 2 decisions in 2014 and 2015 for the 9th Circuit that had to be reversed by the circuit en banc, they keep welcoming him back every year. He's welcome to serve on the circuit courts for the simple reason that he is a fun colleague. And his opinions are always clearly written and understandable. They fairly summarize the facts and the merits of the arguments presented and provide well-reasoned bases for the outcome. And you don't have to take just my word for it. The DC Circuit has said it again and again over the years when reviewing his decisions. In one 1999 case, the DC Circuit said that it was, quote, unnecessary to detail every aspect of the contest that ensued between the parties, since the history of the parties' litigation is amply described in the opinion of the district court. The DC Circuit has described his opinions as recounting the case history, quote, fully and thoroughly, as well as, quote, comprehensive, and simply affirmed for, quote, substantially for the reasons well stated in the district court's opinion. One circuit decision actually, and I've never seen this before, actually included Judge Friedman's full opinion as an appendix to the circuit decision rather than detail all the factual and procedural background, lauding Paul, in his district court opinion, for, quote, providing a reasoned and reasonable explanation for its decision. These compliments are not restricted to just when the circuit affirms his decisions. Reversals, of course, come with the job of being a district court judge. We've all had our share. But the bitter pill is certainly sweetened when the Court of Appeals acknowledges the challenges faced on the trial court level. And I'm going to give you an example of one of Judge Friedman's reversals. Back in 2007, he denied the Federal Trade Commission's request for a preliminary injunction blocking a proposed merger of Whole Foods with another organic grocery store chain. And a divided panel of the DC Circuit reversed. But I quote, they did so saying, reluctantly, admiring the thoughtful opinion the district court produced under trying circumstances in which defendants were rushing to a financing deal deadline and the FTC presented at best poorly explained evidence. This compliment to Judge Friedman was echoed by the concurring member of the panel, stating, I agree with my colleagues that the district court produced a thoughtful opinion under incredibly difficult circumstances. They still reversed him. But the dissent, agreeing with Judge Friedman, was written by a future Supreme Court justice, then Judge Kavanaugh, who described the district court's decision as exhaustive and careful, containing careful analysis with painstaking review of the evidence in the record. So compliments on reversal like this really don't get any better. So no surprise, given Judge Friedman's skill in crafting decisions, that his opinions are frequently cited by his peers around the country. One of his FOIA cases has been cited in over 500 other cases, with several other of his cases in antitrust and APA matters, each cited in hundreds of other decisions. I want to spend a few minutes just highlighting 3 cases that stand out from Judge Friedman's thousands of cases as models that demonstrate his judicial perseverance, his fairness, his ability to explain his findings and rulings, so that not just the parties, but also the public understands the reasons that justice and the law require the result, even if the outcome is controversial. I'm going to start with Pigford v. Glickman, which was a huge, complex case involving a certified class of no less than 20,000 African-American farmers who sued the U.S. Department of Agriculture for unconstitutional discrimination that occurred over a period spanning 25 years, alleging the federal government had denied them access to federal farm loans based on race. These claims had prompted congressional action to extend the statute of limitations to allow certain claims to go forward by the time the case was filed in our court in August 1997. What a perfect case for Paul. A massive litigation stretching back in time across the entire country, already subject to congressional scrutiny, and putting potentially billions of dollars in damages against the US government at stake. So what did he do? He ordered prompt discovery, and he set a trial date for about 18 months after the case was filed. A month before the trial date, the parties proposed a settlement, and Paul had the case resolved in an approved consent decree by April 1999, less than 2 years after it was filed, and the DC Circuit affirmed. Along the way, Paul supervised the notice to class members, outreach around the country, as well as held a fairness hearing so many interested farmers and organizations could be heard. As he summed up in his decision approving the $2 billion consent decree, and I quote, "Nothing can completely undo the discrimination of the past or restore lost land or lost opportunities to all of the African American farmers whose representatives came before this court. Historical discrimination cannot be undone." But the consent decree represents a significant first step, and I would say a very significant step, reached with expedition, and just as importantly, as one person eloquently observed, the most singular achievement of the case remained at its core Judge Friedman's steadfast respect and sensitivity in hearing the voices of African American farmers and all counsel before him, and his restoration of the farmers' dignity through his recognition of the terrible wrongs that they had endured. The African American farmers case was not the only significant civil rights class action lawsuit that Judge Friedman has masterfully handled. He, in the late 1990s, certified a class of special education students and their parents who had been denied their civil rights under the Individuals with Disabilities Education Act, IDEA. He then appointed a very conscientious monitor to oversee how the DC public school system fulfilled its statutory obligations. This case went through multiple iterations of consent decrees until 2006, when he approved a final consent decree that established enforceable standards for timely hearings and implementation of hearing decisions. And one of the mediators appointed to help craft that consent decree has said that, quote, "For all of the frustration experienced in the DC schools cases, the fundamental truth is that Paul Friedman's courageous willingness to act in these cases over time resulted in vitally needed standards and institutional processes to guide the school district's fulfillment of its legal obligations to students with disabilities, and by allowing some of the most disadvantaged families to gain access to relief through the courts. He rescued a remarkable number of children in Washington from the very worst harm and institutional neglect that had become sadly acceptable in this community." That is a remarkable legacy as a judge on just those two cases, as I said, out of thousands. So the last case you've already heard about that I wanted to talk about, which was Paul's steady hand presiding over the case of John Hinckley. That is certainly the case over the last 20 years of his that has drawn the most press attention. This case, as you heard, originated a decade before Paul even took the bench as a judge. It was reassigned to him in March 2001. And then he had to handle this high-profile case over the next 20 years fearlessly, with a focus on the facts and expert recommendations and a clear-eyed view of what was necessary or not for public safety. And then, after all of those hearings, explain each step of the process to a concerned public. By the time of the final order, even the government found no evidence to suggest that Mr. Hinckley's unconditional release should not be granted, and I think that release becomes effective today. Judge Friedman did nothing short but set the standard for how such difficult cases should be handled. So those are just some of Paul's contributions to the law and to justice, but his skill set in managing complex litigation in a changing legal landscape while coordinating smoothly with multiple stakeholders has been relied on heavily by our court and is not very well known at all. Maybe even Liz doesn't know this one, but over the last 7 years, the retroactive reduction of sentences has significantly affected the caseload of every federal district court by reviving long-closed criminal cases. The development is due to sentencing guidelines and statutory changes for drug offenders, along with new Supreme Court jurisprudence finding unconstitutionally vague certain key definitions used in multiple federal statutes, with those findings held to apply retroactively to cases on collateral review. This combination of retroactive sentence reductions across a broad swath of federal criminal cases has necessitated review of hundreds of sentences of defendants sentenced oftentimes decades ago. With the enormous thanks of all of his colleagues on the district court, Judge Friedman took on the task for our court of establishing and then guiding a process with an ad hoc committee with representatives from the U.S. Attorney's Office and the federal public defenders to identify affected defendants, ensure those defendants had legal representation, and figure out which cases could be addressed expeditiously by consent of the parties and which cases presented a dispute to be resolved by a judge. This was a massive undertaking, and that has continued unabated for years now. And due to Judge Friedman's expert handling of this process, dozens of cases have already been resolved in our court. Dozens have been teed up for judges to resolve, all in an expeditious and efficient fashion. To sum up, Judge Friedman is a great judge. Those who appear before him know it. His colleagues know it. His great mentor, Judge Aubrey Robinson, once expressed his ambition thusly, quote, "To live long enough and work long enough to leave a mark on this court, a credible mark, to maybe realize in my own lifetime that it made a difference to the community the court serves that I was here." Paul's already amply fulfilled that ambition of his own mentor. He's left indelible marks on the court and the law more generally. He's made an enormous difference in providing justice to so many individuals in the District of Columbia and even the broader community where our actions as judges on our court reach. He well deserves the award you bestow on him today. And thank you for giving me the opportunity to share my own thoughts about that too. So thank you.
We now have video remarks from Roberta Cooper Ramo. She is a partner in the Albuquerque, New Mexico law firm of Madral Sperling. She was one of the first people in the American Bar Association to focus on law firm management and economics, modern firm management techniques, and the use of technology in the management of law firms. In 1994, she became the first woman ever elected as president of the American Bar Association, a great feat. She was appointed by the United States Senate in 2003 to co-chair a committee to review governance of the U.S. Olympic Committee. Roberta Ramo and Judge Friedman were elected to the Council of the American Law Institute at the same time, and Roberta was elected to a 3-year term as president in 2008. By video remarks, Roberta Cooper Ramo.
The charge of the Edwin F. Jekyll Award is perhaps more deeply important today than at its founding. It is presented to a person who brings honor to the school and to the legal profession. Judge Paul Friedman, in every way, by his service, his integrity, and the use of his wonderful mind, brings honor to the bench, to the bar, and of course to the law school that educated him. I first met Paul well before he went on the bench, when I was running to be the president of the American Bar Association. He was introduced to me by Carolyn Lamb, and to my amazement and gratitude, agreed to, as Carolyn had, support an Albuquerque lawyer running to be the president of the ABA, which, as it happened, had never, in its then 116 or so years, had a woman president. He did everything he could to help, and then he and Carolyn sat with me through the 88 ballots of my first failed try to garner the necessary votes. And he was one of the most persuasive voices to call me to say I had to try it one more time. I can only hope that his against the odds judgment on that point won't cause you to rethink the award. Today, I want to make you aware of his continuing influential work as a member and leader of the American Law Institute. The ALI was founded almost 100 years ago by serious American legal figures like William Howard Taft, Learned Hand, Roscoe Pound, William Draper Lewis, and others. Its mission, in part, is to promote the clarification and simplification of the law and its better adaptation to social needs. Those among you from the world of American law know the ALI because it produces the restatements of the law, the Model Penal Code, and many principles projects, which recently include policing. What was particularly revolutionary and impactful about the founding of the ALI was the idea that it would put a small number of lawyers, judges, and legal academics together to produce its work. For over 30 years, that Paul Friedman has been a member, and he has made deeply significant contributions at every level of the work necessary to keep the ALI founded on sound legal principles, practical, and impactful. He's been at the heart of producing new language for the sentencing sections of the Model Penal Code, as an advisor to the principles of the law of compliance and enforcement of organizations, and at the middle of discussions and drafting of 11 of the ALI's projects. He's given his time to making sure that the ALI is relevant and robust in leadership roles. Today, he's the secretary of the ALI, serves on the executive committee, and is the co-chair of the committee producing the substantive program for the centenary celebration of the ALI in 2023. But even that list understates his importance to the ALI. In this fraught time in American history, when it seems impossible to have civil discussions on important issues of the democracy, the ALI has managed to continue to do just that. There are deeply held views that are opposing on issues that range from how to define sexual assault or consent in the Model Penal Code to issues in copyright and consumer contracts. Paul Friedman presents cogent views of language and impact as we have those debates, and he is very often the person turned to when the language of compromise is required to complete a work. Judge Paul Friedman has unquestioned integrity, a brilliant legal mind, and the amazing ability to see each person before him with a clear, unbiased lens. His life, his career, and his person bring honor to all who have the great luck to work with him, and to me, it is an honor to be his friend. Thank you, University of Buffalo Law School, for recognizing the ongoing important impact of this American patriot.
The next person to make remarks will also be by video. Carolyn Lamb and Judge Friedman were colleagues at White & Case for 18 years before Judge Friedman was appointed to the court. She specializes in international arbitration and is well known and highly regarded nationally and internationally. Carolyn represents foreign countries and multinational companies. She was president of the D.C. Bar and later the American Bar Association. And today, the greatest tribute and credit I can state about Carolyn Lamb is that she hails from Buffalo, New York. Carolyn Lamb.
I applaud Buffalo Law School for conferring the prestigious award on Judge Paul Friedman. I am honored to pay tribute to a great lawyer, wonderful partner, and friend. For many years, Paul and the other partners at White & Case and I were delighted to have the opportunity to practice law together. From that perspective, I want to share with you a few of my reflections about his extraordinary contributions to our law firm and to the profession. Paul practiced law as well as it could be practiced. His professional excellence was the product of a unique combination of excellent lawyering and outstanding interpersonal skills. While at White Paul, of course, was one of our star litigators and a lawyer with the intellectual capacity to master the most complex and novel legal issues and the most difficult factual issues. He also brought into his analysis common sense and practicality, which clients applauded. He always treated others, his clients, his colleagues, young and old, with warmth and compassion. All at White and Case consulted him for his wisdom and judgment on difficult issues. His easygoing manner makes others feel comfortable and permits him to put aside animosity that might interfere with the resolution of legal issues. Many of our clients turn to Paul with difficult, complex corporate takeover contest litigations. He defended white collar criminals, antitrust fraud, procurement investigations, and prosecutions. In fact, in one takeover contest, he represented a client in the courts of Washington, New York, Bermuda, and the UK. At the same time, he made time to represent and defend a political refugee about to be deported, and he helped establish the ABA's Commission on Homelessness. At White and Case, Paul, as our appellate guru, handled many cases in the courts of appeals around the country and the Supreme Court. Paul's most brilliant case was his representation of Saudi Aramco in EEOC versus Aramco. In that case, the Supreme Court considered whether employment discrimination provisions of Title VII applied to U.S. employees, often in workplaces outside the United States. He argued that Congress never intended Title VII to apply overseas. Aramco prevailed with a 6-3 Supreme Court decision, but Congress promptly changed the law. He also was a wonderful partner in charge of our Washington office. He led the office through challenging times, and he was truly an extraordinary and outstanding lawyer, mentor, teacher, and gentleman. Paul, together with his wife Liz, contributed a great character and humanity to our office. Under his leadership, White and Case, Washington, D.C., was a special place, stressing the highest professional excellence, marketplace competitiveness, but with an internal atmosphere where each lawyer and each staff member's abilities were respected and encouraged, and relationships forged. His door was always open to offer words of praise and encouragement. Paul left us a great legacy at White and Case with the distinction and care with which he served. He contributed greatly for 18 years, promoting the values and ideals that established White and Case and enabled many of our alumni to become great lawyers, as well as many great lawyers at White and Case, encouraged to do the best they could ever possibly be. We have missed him greatly over the years after he ascended to the federal bench. He was the first White and Case partner to do so. He has had an exemplary career as a lawyer. We applaud him, we honor him. He has enriched our lives and served our entire firm and community and contributed to our nation's jurisprudence as well.
It is difficult to know where to begin when introducing Jamie Gorelick. Jamie Gorelick and Paul Friedman first met when they served together on the DC Bar board in the early 1980s. At the time, Paul was president of the bar. Jamie later became president of the bar. She's had a distinguished career in both the public and private sectors. She was general counsel of the Department of Defense, appointed early in the Clinton administration, and then, for over 3 years, she was the Deputy Attorney General of the United States under Attorney General Janet Reno. After 9/11, she was appointed to serve on the 9/11 Commission on Terrorist Attacks, chaired by Senator Keene and Representative Hamilton. Since 2003, she's been a partner at WilmerHale, chairing the Regulatory and Government Affairs Department. A distinguished lawyer, Jamie Gorelick.
Thank you, Cousin Bob, as he is known to everyone in Washington, just so you know. Just so you know. Chief Judge Howell, friends and new friends, Judge Friedman, Liz Friedman, and the Buffalo family. I want to start out by expressing, if I can, for the lawyers in DC, the sorrow that we feel for the Buffalo community, as our friends from Buffalo have described it, and know that you have our support as you try to deal with that tragedy. Paul is one of the very few people that folks in the DC Bar know from Buffalo, but he's a great advertisement for your city. He is a loyal fan of Buffalo, and he's treated many of us in DC to great Buffalo stories about his upbringing in the Buffalo community, and suffice it to say, he does you all very, very proud. You know, I've had the honor and the pleasure of roasting and feting Paul in many, many occasions, starting with his investiture as a judge in 1994, when I was deputy AG, and he asked me to come and present his commission. And I won't repeat what I did there, but just to say that I pretended, although I don't know that the court knew that I was pretending, to read from his FBI file to make sure that they knew what they were getting into when he joined them on the bench. And I started off by saying that the first entry in his FBI file was from his mother's Buffalo OBGYN, who, in handing baby Paul to his mother, said, "This baby looks like he was born to be a judge." And I followed from there. But again, I'm not going to rehearse that because Paul and Liz, who are, of course, the most important audience here, have already heard this. Now, it has been very easy to vet Paul over the years because he's good material. Because you can hear it in everything that has been said so far. He has packed more into one career than anyone I know. It is just extraordinary. And so there's a lot to choose from. So, you know, Chief Judge Howell is much more knowledgeable than I am about Paul's career as a judge. So I want to spend a few minutes on why your honoree deserved this honor when he was pre-Judge Friedman. He burst onto the scene, as Carolyn Lamb and others have said, as a star in the U.S. Attorney's Office and then in the Solicitor General's office. And that's when I actually did come to know him, because he established in a short period of time his credentials as a superb lawyer. He had a reputation when he left the government for being this thoughtful, persuasive advocate. And he developed not only skills as a lawyer, but values as a lawyer in his public service. And that those values have held him in good stead as a judge. If you want to know why I say that pre-Judge Paul Friedman would have deserved this honor. I want to give you five just brief examples of what he did for this community between the time that he served in various positions on the DC bar and when he ascended to the bench. He was overwhelmingly elected as DC bar president and served with distinction in 1986 and 1987. But I want to put that election in perspective for those of you who don't know the DC bar all that well. The DC bar membership is about the size of a congressional district. We have today 110,000 members, a few fewer back then, but that's about 10% of all the lawyers in the country. Now, some people would take that job and just bathe in the honor of it, but not our Paul. He became concerned, so this is my first example of, in my case, for the Jekyll Award for the pre-judge Paul Friedman. He became concerned about homelessness in DC, which was a terrible problem then as it is today, but it was really quite palpable in the community. And he decided that lawyers could be an important part of the solution. Helping people, we could help people get benefits to help them get back on their feet. So he, my word, corralled a bunch of us in the bar to start a pilot project, which we started with 40 volunteers in 4 intake sites. And that little project became the Washington Legal Clinic for the Homeless. And I'm going to read you its mission, which is to use the law to make justice a reality for our neighbors who struggle with homelessness and poverty. He then joined the board of this little organization to make sure that it would actually make justice a reality for those neighbors of ours. And he used the force of his own persuasion, I can tell you because I was on the receiving end of quite a bit of that, to get the leaders in the bar, the leaders in our law firms to back the idea with their time and with their money. Since then, our legal clinic has served 41,000 clients, helping them to get back on their feet. And as Carolyn and I think Roberta mentioned, Paul's efforts starting a stellar and needed organization from scratch based upon an observation of the problem and his own construction of the solution, that earned the DC Bar, the American Bar Association's Harrison Tweed Award, which is given for significantly improving the quality of legal services for persons living in poverty. But second, he wasn't content just to have this very successful project in Washington. He took it on the road. He took the proof of concept that the Washington Legal Clinic was, and he said this should become the standard in every community around the country. So he chaired the ABA's Commission on Homelessness and Poverty to spread the model across the country. Third, and you can see it in other remarks here today, but also, frankly, in the lineup of the speakers today, Paul is and has been a consistent proponent and champion for diversity in the bar and in our courts. During his time as bar president, he appointed a committee on gender bias in the courts. And he named 3 outstanding, and I would say outspoken, women to lead that effort.
You were one of them.
Yep. And that report, at Paul's urging, ultimately became the prod for our own DC Circuit to have a similar effort, and the recommendations of that gender bias task force were both far-reaching and really impactful. So again, a concept taken to reality with a kind of steadfast effort. Fourth, as Chief Judge Howell said, Paul was concerned about lack of diversity in our courts themselves, and he railed, although I would say, Chief Judge Howell, in the nicest possible way, against the failure of the Reagan administration to have any diverse appointments. Between when President Reagan was elected and when Paul was elected bar president, President Reagan had nominated and had confirmed 14 white males, and Paul thought, that's not really what we should be doing here in DC. So he put together a coalition of all the different bar associations in DC, which we happen to have 33 of them. He wrote op-eds. He testified before the Judiciary Committee. He repeatedly met with White House counsels, and he urged a broader look at the talent that would be available in this jurisdiction. And then he went further as he was named to Congresswoman Eleanor Holmes Norton's Judicial Nominations Commission and helped 19 women and minorities become judges in D.C. In just a relatively short tenure. And I can tell you, as a woman rising in the bar just behind Paul, his openness to women and minorities was reflected in his appointments in the bar and just the way he dealt with us. So we welcomed Paul into the Women's Bar Association, and the Hispanic Bar Association followed, and the Washington Bar Association, which is the home, the voluntary bar for black lawyers and judges, did the same. And that may seem symbolic, but it was very impactful in our community. Last, I want to talk about one other thing that Paul did. He turned the untimely death of our revered friend and colleague in the bar, Fred Abramson, into another opportunity to give back to our community. He started a foundation in Fred's name that gave financial and mentoring support to graduates of DC public high schools as they entered college. And it also gave fellowships to law students, law grads who wanted to give back to the community. It is, and that foundation thrives today, and it helps so many young people get an education. I want to note that in all of these endeavors, Paul and Liz have been a team. They are passionate about the challenges in our society and thoughtful about the solutions. And when they set their minds to a problem, you do not want to stand in their way. The combination of determination and charm is something to behold. And so in DC, we owe you two a debt of gratitude. So I've given you just 5 examples of the public-spirited arc of Paul Friedman's career. And as you've heard from Chief Judge Howell, he carried those values onto the bench, where I and my colleagues and friends in the bar know him to be smart, unfailingly fair, calm, patient, and indeed just. What pre-Judge Friedman did is also characteristic of what Judge Friedman did in his career as a judge and is still doing to this day. It is not enough. I look for the common thread, and here it is. It is not enough to have a good idea. Success depends on how you execute against the challenge. It's not enough to note the problem of homelessness. You need to create and build support for lasting institutions to attack the problem. It's not enough to rail against the lack of diversity in our profession and in the courts. You need to identify the obstacles to fairness and attack them with passion, one at a time. It's not enough to talk about collective action. You need to meet with and listen to everyone, hear the perspectives, and bring people together as a cohesive force. This pre-Judge Friedman is of a piece with what Judge Friedman has done. It's not enough to see if there could be a just result for those black farmers. You need to listen to them. You need to hear them and patiently fashion a solution. It's not enough to reflect on the lack of access that kids in this city had to special education when they needed it. You need to get underneath and understand how the system works if you're going to rescue children from institutional neglect. And so it's this combination of insight and execution, brilliance and fairness, patience and urgency that characterize the life and work of our friend Paul Friedman. So now I rest my case that both you guys are derelict at the University of Buffalo. Both the pre-judge Friedman and Judge Friedman are amply deserving of this award. And I speak for, and I'm just going to be preemptive here, I speak for the entire DC Bar community in thanking you for bestowing this award on our friend. Thank you.
Thank you, Jamie. It's obvious that you're lobbying for an invitation to one of our Cousins Club gatherings. Don't beg, Jamie. By video remarks, our next speaker is a judge of the D.C. Circuit Court of Appeals, the Honorable David Tatel. Before becoming a judge, he was a major figure in the public interest world. He'd been a national director of the Lawyers Committee for Civil Rights under the law, and later director of the Office of Civil Rights in the Department of Health, Education, and Welfare. He left government and entered private practice at Hogan and Hartson, which is now Hogan Lovells, where he headed their education practice. He was appointed to the United States Court of Appeals by President Clinton in 1994. I recall meeting with Judge Tatel when Judge Friedman gave me a tour of the courthouse. And when we entered Judge Tatel's chambers, he walked us room by room, explaining what personnel occupied each room and what their functions were. You would not have known he was blind, nor would you know that by his service on the court and his contributions to the cause of justice. By video remarks, the Honorable David Tatel.
Since Paul and I joined our respective courts some 28 years ago, I've reviewed dozens of his decisions, civil and criminal, big and small. We don't always agree, although we do most of the time. But in every case, a Judge Friedman decision is a pleasure to review. Careful fact-finding, sometimes even crafted to lock in the appeals court. No one does that better than Judge Friedman. And of course, clear, crisp legal reasoning. My favorite is United States against Villanueva Centella. The question was this: to obtain a conviction under the identity theft statute, must the government prove the defendant knew the identification actually belonged to another person, or only that it happened to belong to another person? This was a tricky question. That is, until I read Judge Friedman's decision and his colloquy with the prosecutor. Judge Friedman, what if you make up a number that doesn't belong to anybody? Prosecutor, then you don't charge the offense. Judge Friedman, so if the defendant picked a number out of the air and it was your number, he's guilty. But if he picked a number out of the air and the government hasn't assigned it to anyone, he's not guilty? Prosecutor, that's correct. That was all His Honor needed to decide the case. And it was all I, quoting that colloquy in my opinion, needed to affirm. And it was also all the Supreme Court, having granted cert to resolve a circuit split, needed to affirm unanimously. So after 6 circuit court decisions involving 18 judges and consuming 70 pages of Fed Third, and a Supreme Court decision and 2 concurrences consuming 10 pages of U.S. reports, we were right back to Judge Friedman's 4-line colloquy. Paul's remarkable judging is also evident in 2 judicial experiences he and I shared. Judge Friedman presided over a major class action against the DC school system, which had failed to meet its legal obligations to special education students. After granting summary judgment to the students, Paul turned to the complex question of remedy, and at his request, I served as a mediator and, as a sitting federal judge, had the opportunity to appear before Judge Friedman and present the settlement. It was clear to all that the mediation succeeded only because of the clear parameters Paul had set. Judge Friedman and I also sat on the 3-judge district court that heard Northwest Austin against Holder, the predecessor to Shelby County. It was such a thrill to sit next to Paul in the ceremonial courtroom and watch this gifted judge preside over a complex oral argument. And although I authored the opinion, you can see Paul's fine hand at work in its comprehensive findings of fact and alternative holdings. Paul, if our dear friend Jim Robertson could be here today, I'm sure he would have said of you what he said of our other dear friend and colleague, Lou Oberdorfer, at Lou's portrait hanging. Quote, calls them as he sees them, innocent of judicial activism. His decisions will resonate in the history of our court for years to come. End quote. So, my friend, congratulations on this lovely award from your alma mater.
Our next speaker, also by video, is someone who needs little or no introduction. Nina Totenberg is a National Public Radio's award-winning legal affairs correspondent. Her reports are regularly seen on NPR, and she has received widespread recognition. In 1991, her groundbreaking report about the University of Oklahoma law professor Anita Hill, allegations of sexual harassment by Judge Clarence Thomas, led the Senate Judiciary Committee to reopen Judge Thomas's Supreme Court nomination. NPR received the prestigious George Foster Peabody Award for its coverage of the hearings, all anchored by Nina Totenberg. By video, Nina Totenberg.
Paul, I doubt, would consider himself a hero, but there are times when you can see the stuff a judge is made of, and I'm going to talk briefly about 2 of them. The first was Paul's handling of John Hinckley's case post-trial. Hinckley, you'll recall, was charged with shooting President Reagan and his press secretary, Jim Brady, who suffered major brain damage. A jury found Hinckley not guilty by reason of insanity in 1982. Judge Friedman was not the trial judge. He was assigned the case more than a decade later. At that time, no judge had allowed John Hinckley to leave St. Elizabeth's, ever. But slowly, very slowly, over the years, Judge Friedman began letting him spend first a weekend, then another weekend with his parents, then more weekends. He assembled a group of experts to evaluate Hinckley, tested him in different settings, and at each stage opened the door a tiny, tiny crack more. None of this was popular, of course. The Marshal Service at one point determined that he needed round-the-clock protection, and he got a letter from Jim Brady's wife, Sarah, urging him not to let Hinckley out, which, with her permission, he released. But ultimately, after nursing this case along for some 25 years, Judge Friedman found that Hinckley's mental health afflictions had been in remission for years, and he released him. He threaded an incredibly difficult needle, and he demonstrated the courage and skill to do it the right way, so that by the time Hinckley was released, even the psychiatrist who for years had been arguing to keep him locked up now thought it was okay to release him. The other case that I want to talk about, I'll do through the eyes of my sister, Federal Judge Amy Totenberg of Atlanta, who at Paul's portrait hanging was selected to represent all the special masters who had reported to him over the years. She had been one of those and talked about the class action cases that involved institutional failures that have affected the lives of not one, but thousands and thousands of people. Cases that, as she put it, most judges try to avoid because the evidence is so complex and the remedial relief extraordinarily complex to administer. These too are cases that are charged with acrimony, risks of public criticism, and are voraciously time consuming. And yet they also touch the heart and soul of the American justice system. Judge Friedman has, with unfailing energy and judgment, handled many such cases. To cite just one, the so-called Black Farmers case, in which he tackled the history and reality of deep systemic race discrimination and bureaucratic failure in the Agriculture Department's loan, credit, and benefit programs. As he put it in the order he wrote in 1999, nothing can completely undo the discrimination of the past or restore the lost land or lost opportunities to all African American farmers who were eligible for but denied loans and other opportunities just because of their race. But this consent decree represents a first step, a step that has been a long time coming. With those words, Judge Friedman launched a massive effort to reach out to Black farmers, to assist them in pursuing claims. Ultimately, almost 16,000 received compensation, totaling roughly $1.1 billion. As the government's counsel would put it when it was over, quote, courts don't have armies, so a court's power derives from the respect it commands. In Judge Friedman's case, he received the maximum respect from the parties because he demonstrated over more than a decade that he was entitled to it, close quote. One of the lead lawyers for the Black farmers, J.L. Chestnut, would put his experience this way. It was in Judge Friedman's courtroom, as later with my standing ovation by poor Black farmers, that I came to understand that my life has not been in vain.
For our final presenter before the presentation of the Jekyll Award, by video, a woman who served as a law clerk for United States Supreme Court Justice Stephen Breyer from 1999 to 2000. She was Assistant Special Counsel to the U.S. Sentencing Commission from 2003 to 2005. In 2012, President Obama appointed her to the United States District Court for the D.C. Circuit. In 2021, President Biden appointed her to the Court of Appeals. In 2022, President Biden appointed her to the United States Supreme Court, and she was subsequently confirmed by the United States Senate. I present Judge, soon to be Justice, Ketanji Brown Jackson.
Hello, University at Buffalo School of Law alumni. This is Ketanji Brown Jackson, and I want to offer my heartfelt congratulations to Judge Friedman on receiving the 2022 Edwin F. Jekyll Award, which is the highest honor the University of Buffalo School of Law and its Law Alumni Association can bestow. Judge Friedman is a brilliant attorney and jurist and has tirelessly given so much to others in various ways, including serving as a mentor to me and many other judges and lawyers. Judge Friedman truly deserves every accolade, including this award. Few people know this, but Judge Friedman was among the very first people to encourage me to seek judicial office. And I was privileged to serve alongside him on the district court for the District of Columbia for over 8 years, during which time he was a fabulous colleague and friend, always giving the best advice, exuding good humor, care, and the utmost concern for the well-being of his colleagues. Judge Friedman warmly welcomed me and provided invaluable advice and insight when I was setting up my chambers and figuring out how to be a federal judge. And I always looked forward to visits to his chambers, both because he is such a good listener and because those visits gave me a chance to admire his chambers decor. He has impeccable taste. And I confess that I mirrored some of his chair choices when outfitting my own chambers on the circuit court. Judge Friedman is also very well known and widely celebrated for the courage and conviction that is clearly exhibited in his work, and the clarity with which he has expressed his views in some of the most notable opinions, from the Black Farmers Settlement to the Hinckley case. Judge Friedman has handled some of the most high profile and complex legal issues, and he has done so with unmatched poise, insight, and exceptional analytic ability. Judge Friedman, thank you for all that you've done to honor us fellow jurists and to uphold the rule of law in our circuit. You are an inspiration to so many people. Unfortunately, I cannot be there to celebrate this special day with you, but I send you my warmest congratulations and best wishes.
Let us thank all the presenters for their great commentaries here today. And now, for the presentation of the Edwin F. Jekyll Award to the Honorable Paul Friedman, the Dean of the Law School, Aviva Abramovsky, and the President of the Law Alumni Association, Jeffrey Struvino.
It's under there. They hit it.
Judge Friedman, on behalf of the University of Buffalo School of Law and the UB Law Alumni Association, I'm honored and privileged and proudly present the 2022 Edwin F. Jekyll Award to you, class of 1968. And the award reads, in recognition of his extraordinary contributions to the law and the legal profession. This award is the highest honor of the UB School of Law and the Law Alumni Association they can bestow. Judge Friedman, as we've heard, has demonstrated extraordinary leadership both in private practice and in public service. Throughout his distinguished tenure on the federal bench, he has ruled on many nationally noteworthy and high-profile cases. He has earned the respect and admiration of his colleagues in the judiciary and the bar for his dedication to the law and for his unquestioned integrity. As an emeritus member of the Dean's Advisory Council, he has consistently shown support for our students and brought credit to the university and the law school. Congratulations. What a great program.
Well, I've been advised over the last few days not to ad lib, just give the remarks as you wrote them and as I edited them, unless you can make them shorter. But I have to say that first, it's good to hear this while I'm still alive. But secondly, you know, listening, I'm really humbled by all of this. But in a way, it's sort of like the trajectory of my life, you know, starting with Bob, who I grew up with, and his wife Eileen, whom I've known since high school, through Carolyn and Jamie talking about my years at White and Case and my years doing things for the bar, and now with Beryl as my chief, it's sort of like from the beginning to the end, and not the end, but to today. So I will stick mostly to what I had planned to say, although I'm going to try to be a little briefer. First, I do want to thank the Dean very much, and to Jeff. And although I think I just met Jeff for the first time today, he told me that he actually went to undergraduate school with Ketanji and her husband Patrick, and knew Patrick, Judge Jackson, pretty well. The Dean and I, of course, have known each other for the last several years and have done at least one moot court together, and she's been down here for these alumni events. But I can't tell you how profoundly meaningful it is for me to get this award, particularly at this point in my life and this point in my career. And thank you, President Tripathi, for coming today and being here for this. And we've met a couple of times before, and we had a very nice chat earlier today. As has been mentioned, I grew up in Buffalo. I went to its public schools. I then headed off to an even colder and snowier climate by going to Cornell for 4 years. And then I started law school at NYU. But I found that at that time in my life, I was just not happy in New York City. So I came home to Buffalo, hoping to find at the University of Buffalo what I had not found in New York, a sense of why I had chosen to study law in the first place. Difficult as it is to fathom, it's been 54 years since Bob and I graduated from Buffalo Law School. And 54 years next month since my classmates, Stuart Bedell, Gary Cohn, Harold Denkner, and I, ventured out from Western New York to begin our legal careers here in the nation's capital. Stuart, Harold, and I driving a rented truck packed with hand-me-down furniture for our apartment for relatives. And Gary to start his life here with his new bride, Lynn. Sadly, Harold died 6 years ago, and our good friend Gary just this last January. A few of you, maybe nobody in this room, but some who may watch this later, may remember that Buffalo Law School 54 years ago was a small and cozy place. There were only 84 students in our class, and all 3 classes were crammed into a small 1940s-style building down on West Eagle Street in downtown Buffalo. Tuition was, believe it or not, $800 a year. But Buffalo Law School provided me with just what I was looking for, a reassuring environment where I could not only learn the law, but also learn to think like a lawyer. Somewhat to my surprise, this environment made me into a much more dedicated student than I'd ever been before. And professors like Jack Hyman, Lou Delcato, Ken Joyce, and Wade Newhouse, all of whom were prior recipients of the Jekyll Award, as well as my good friend Herman Schwartz, just retired from American University School of Law, all helped bring the law to life for me, to make it interesting both intellectually and practically. And as importantly, they opened my eyes to the world of possibilities that a career in the law could offer. They encouraged me to think big. And so with good grades, my law review experience, and a lot of luck, I was able to get a federal district court clerkship here in Washington with Judge Robinson, and then on the Court of Appeals with Judge Robb. Now, I'm not going to dwell on my time in the U.S. Attorney's Office or the Solicitor General's office, or on my 18 wonderful years at White and Case, and I'm so grateful that some of my former colleagues are here today. Those were great times. Nor will I run the risk of boring you even more with tales of my 28 years, hard as that may be to believe, for me to believe. 28 years as a federal judge. Beyond saying this, I still come to work happy every day, although work for the last 2 years has been out of our dining room mostly. I still come to work happy every day, or nearly every day, looking forward to both the anticipated and the unanticipated events that inevitably unfold in the life of a judge. There are lots of new things under the sun, it turns out, even after 28 years. So I really am humbled and almost embarrassed by the very generous remarks of all of the speakers today, and I'm grateful to all of them for their kind words and for their friendship and for their support throughout the years. Specifically, my cousin, Bob, who is known to Jamie as Cousin Bob, because Jamie and several of my other friends in Washington, every time they need a lawyer or a client of theirs needs a lawyer in Buffalo, they say, well, who shall I call? I said, well, call my cousin Bob. So over several years of phone calls, I gather, Jamie now calls him Cousin Bob, too. I appreciate Bob for many reasons, one of which is for many of the things he didn't say here today. I must have sounded like the perfect kid if you listen to him. There are lots of stories, and they will go untold. But the truth is that we were practically inseparable growing up in grade school and high school. We lived on the same street, as did our other cousin, Alan Carroll, a former associate dean of the law school. And we were best men, as Bob said, at each other's weddings. So Bob, you know that today would not have been nearly as meaningful without you being here and you presiding, and without all the time and effort you've devoted in advance. And just alluding to Beryl's remarks for a minute, yes, when I was appointed to the bench, the group of us during those early Clinton years were known as the Magnificent Seven. But Bob and I had the temerity or the chutzpah or something to call ourselves and our 5 best friends in high school the Magnificent Seven. So I actually learned a lot today listening to Chief Judge Howell about my career, a number of opinions I've written, and so forth. And her reference to my testimony and my work as president of the bar about getting a more diverse bench here. It is true, so far as I can tell, that no judge on the Court of Appeals has ever held that against me as they review my decisions. But there is that occasional discussion in the judge's dining room when Judge Sentell, with his wonderful deep Southern accent, says, "And then there was a time that Paul testified against me." And I said, "David, it wasn't against you." But Beryl, Chief Judge Howell is the 6th chief judge with whom I've served, and we've become good friends. And I appreciate this relationship. But you all ought to know that it's hard to imagine how the wheels of justice would have kept rolling so smoothly under another leader, a less forceful, a less decisive, and still collegial leader than Beryl has been during the pandemic, and particularly after the influx of nearly 800 new criminal cases flowing from the January 6th insurrection. Herding 20 cats when each one of us has life tenure isn't easy, even in simpler times, but somehow, Beryl, you've managed to do that and so much more, and it's so appreciated. Now, Jamie and I have been good friends, along with Liz and Jamie's husband, Richard Waldhorn, for almost 40 years. And we've been through a lot of stuff together. They've been great supports to us, both personal and professional, over many, many years. And it is still appreciated. They're very, very close friends. Jamie's discussion about my efforts to seek a more diverse court over the years when I was president of the bar and active in the bar. I do recall this, however. We succeeded. And when I was on the DC Judicial Nominating Commission with the local judges, and through my testimony, not mine alone, but all of the bar associations coming together, we succeeded so well that when President Clinton became president, and I thought I might have the opportunity to become a federal judge, lots of my friends said, "You know, all those things you worked for, they may not serve you in good stead right now." Fortunately, there were 4 vacancies at the time, and it worked out just fine. I want to go back to one thing before I get to the other speakers. On the issue of diversity, Liz pointed out to me as we were getting ready for today, she said, do you realize that the only man other than Bob speaking on this program is David Tatel? But I guess these are the people that I'm close to, that I've worked with and that I care about a lot and care about me apparently, and I'm grateful for that. But on the subject of Judge Tatel, Judge Howell mentioned this Federal Trade Commission case, and under that statute, we had 10 days to review everything and get it done, and the piles of depositions and everything in the conference room, and Carolyn Platt over there and I worked day and night to try to get it right. A year earlier, there was a panel of 3 judges who were asked to stay things. And am I thinking about the FTC case, or am I thinking about the? And they were asked to stay things, and 3 judges decided not to stay or enjoin things going forward. Among them were Judge Tatel, my good friend Judge Tatel, and Judge Kavanaugh. So we fast forward a year, and they hadn't stayed things, and the merger went forward, and I ruled, and a year later, I get reversed. And I'm supposed to put the toothpaste back into the tube after the merger had happened. And this was we get reversed. And sometimes they're right, and sometimes we still think we're right, but it's within the realm of reason. But this was the one I was the angriest about, particularly since they could have stopped it and didn't. And that one of the judges, who happened to be my best friend on the circuit, voted to reverse me with all these very kind words. And I was too angry to talk to Judge Tatel. So I picked up the phone and I called Judge Kavanaugh, and I said, you know, Brett, it's very nice that all 3 judges complimented me, but I could have used just a one-word compliment. He said, like affirmed? David Tatel and the others who spoke today, Carolyn, I mean, what can I say about Carolyn that's been said? She and Peter Halley, her husband, are among our closest friends. And Roberta and Nina and David are all good friends, and I very much appreciate their words. As for Judge Jackson, all I can say is if you watched any of her testimony before the Senate Judiciary Committee, you saw who she really is. She is brilliant, she's compassionate, she's charismatic, she is a very, very grounded person. I couldn't be happier. And I'm telling you, the court and the country will be so well served by Justice Jackson for decades and decades to come. Okay. And speaking of important people in our courthouse, at this table and at that table are a dozen of my present and former law clerks. I've had a total of 37 law clerks over the years, and my relationship with them has been one of the greatest joys I've had as a judge. To work every day with such bright, creative, dedicated young lawyers who do their best to really get it right and to make me look reasonably good while doing so, and apparently drafting thousands of opinions, is a genuine privilege. They open my eyes to new ideas, continue to bring me joy and pride in their accomplishments, and help keep me young. Also at one of those tables, and I shouldn't point, but right over there, and the clerks know who I'm talking about, and so do my friends from White and Case, is Marissa Ahari, who was my right arm for 37 years. 10 years at White and Case and 27 years as my judicial assistant at the courthouse until she retired in March of this year. Marissa and I have been a great team, and she knows just how much I appreciate her. So I was about to say finally, but I do have a few little things I want to say after these thank yous. But finally, on this day, and on all significant days, and even more importantly, on the ordinary days of our lives, Liz has been by my side for 47 years of marriage. Without her, much of what I've accomplished, as my friends here know, would not have been possible. She's made me a much better person, and she's made me a better judge than I would have been without her. Now, when Eileen and I talked about this day a couple of years ago, she said, well, you should conclude with some remarks about the state of the legal profession and the courts. And, you know, that's tempting. As my colleagues and I deal with our almost 800 capital insurrection cases, I have about 25 or 30 of them myself, and all of us here today and throughout the country reflect on the mass shootings in Buffalo and in Uvalde, Texas, and in too many cities and towns across the country. I worry about whether some of my friends on the Supreme Court, like too many in Congress and some of our fellow citizens, have simply lost touch with reality. We'll see. And so I thought about whether to speak yet again about the importance of the rule of law and the institutions entrusted with it, and about how judges need to be more than just strict interpreters of sometimes arcane language. They also need to consider the impact their decisions have on the lives of real people in today's world. But knowing this group, I'd likely be preaching to the choir. It's obvious to everyone here what's at stake for democracy. So I want to speak briefly, more personally, from the perspective of a senior judge, a senior person, really, looking at the bigger picture. Lawyers and judges focus so much on their daily lives, their daily work, their clients, their cases, their trajectory. The pressure to succeed, to impress, to make one's mark, to put in the hours, can dwarf the fact that we are not just practicing law. We are, much more importantly, living our lives. So we need to surround ourselves with people we like, with people we respect, people we can trust, people who will support us and who we can turn to in both the good times and the tough times, as well as those whom we want to support. The mundane, the ordinary, the private moments, the interpersonal, the joys, the annoyances, these thousands of small things are what day-to-day existence consists of, and in the end, are what really matter. Our lives are not just mountaintops we occasionally reach, or attempt, or the strokes of genius. Our lives consist of our attempts to be good people and to find or try to find satisfaction, both professional and personal. So each of us needs to find not only the right circumstances in which to live our best lives, but the right people with whom to live it. And sometimes one needs to make a change to make that happen. If you don't find satisfaction in one job or firm or type of practice or lifestyle, or a supportive environment with people you connect with, don't hesitate to make a change in order to find that satisfaction in what you do and with whom you do it. Always remember, a life consists of many chapters. For me, looking back, I've been very lucky, or smart, or something. I find myself today a satisfied person with my choices over the years of where and how to practice law, with my incredible good fortune of having the best job in the world for the past 28 years, and with Liz and so many of you in this room today by my side along this journey. And I'm very grateful to Buffalo Law School for having gotten me started down that path, and extremely grateful for the honor you've given me today. Thank you all so much for being here and for a truly incredible day. Thank you.
On behalf of all assembled, congratulations again, Judge Paul Friedman, and I bid you all a good afternoon.